Hey everyone, and welcome back. Ready for another deep dive?
Always.
Today we're going to tackle a topic that's pretty heavy but really important, and that's sexual offenses within UK law.
It's a big one.
It is. We're going to be looking at excerpts from a UK law lecture that focuses on, you guessed it, the Sexual Offences Act of 2003.
The SOA 2003, a landmark piece of legislation.
Exactly. And we're going to break down all the legal jargon, all the key elements, so you don't have to be a law expert to follow along.
It's fascinating how this act tries to define something as nuanced as consent and then builds a whole framework of offenses around it.
Yeah, consent really is at the heart of it all, isn't it?
Absolutely.
So let's jump right in with the big one. Rape.
Okay.
The lecture pulls the legal definition straight from Section 1 of the SOA 2003. And it goes like this. A person commits an offense if, and I'm quoting here, he intentionally penetrates the vagina, anus, or mouth of another person with his penis. The other person does not consent to the penetration, and the perpetrator does not reasonably believe that the other person consents.
So 4 key elements to prove for a rape conviction.
4 elements. And, just to be clear, rape can happen to anyone, regardless of gender.
Yes, the definition explicitly protects men and transgender individuals.
Now, the lecture really dives into this next part, and it gets complex, the whole concept of consent, how it's woven into both the physical act of the crime, the actus reus, and the mental element, the mens rea.
Right.
According to the SOA, consent means a person agrees by choice and has the freedom and capacity to make that choice. Sounds simple enough on paper.
It does, but in reality, not so much.
Not so much. Take, for example, the case of R.V. Kirk.
Ah, yes. A good illustration of how consent isn't always clear-cut.
The lecture highlights this case involving a young, vulnerable homeless girl. She engaged in sex for money. No overt force, nothing like that. But the court still upheld a rape conviction.
Because her circumstances meant she couldn't truly choose freely.
Right. Undue pressure. Basically negated consent, even if it didn't fit that, stereotypical image of a violent attack.
It's a good example of how context is crucial in these cases.
Yeah, context is everything. And the lecture goes on to contrast R.V. Watson, a case where a woman submitted to sex out of fear.
With R.V. Oleboja, which distinguishes between submission and reluctant agreement.
Right. So even if someone seems to agree, the question is, was it truly a free and informed choice?
Exactly. And then we have the whole issue of capacity to consent. Can someone truly consent if they're intoxicated or mentally impaired?
Right. So the lecture uses R.V. Cooper to illustrate this. It shows how capacity is more than just understanding the physical act itself.
It also requires the ability to weigh the decision, to understand the implications, and make a reasoned choice.
Which brings us to intoxication, another layer of complexity. Even if someone's conscious, being drunk can really impact their capacity to consent, as seen in R.V. codes.
It's a tricky area, and it all comes down to whether they could genuinely understand and consent to what was happening.
Right. And then there's R.V. Heisa.
A case that brings together so many of these issues. Intoxication, vulnerability, the absence of a clear no.
It really highlights that consent is not passive. It has to be active and freely given.
It does.
The lecture even mentions, and this is kind of shocking to think about, the historical marital rape exemption.
Ah, yes. A reminder of how far we've come, thankfully.
It wasn't until RVR in 1991 that this exemption was abolished in the UK.
In R.V. Barry C., where a man was convicted in 2004 for a rape that happened back in 1984, shows how long the fight for justice can take.
It's a chilling reminder that this wasn't always considered a crime.
It is.
Okay, so we've talked about the actus reus of rape, the physical act.
Yeah.
But what about the mens rea, the mental element?
The lecture zeroes in on no reasonable belief in consent as a crucial factor in establishing the mens rea for rape.
Okay, so it's not just about what the defendant thought. It's about whether a reasonable person in their position would have believed there was consent.
Exactly. It's not purely subjective. What steps did they take to ascertain consent? Did they genuinely believe it was given, and was that belief reasonable?
So like in R.V. Bram, even though the defendant had a mental disorder that affected his thinking, it didn't excuse his lack of reasonable belief in consent.
Right. The law holds us accountable even when our mental state might influence our choices.
And what about intoxication? Like, if someone's drunk, can they claim they reasonably believe they had consent?
No, the lecture's very clear on that. Self-induced intoxication cannot be used to establish a reasonable belief in consent.
That's interesting.
R.V. Grinnell really solidified this. The court said that a drunken belief, even if genuine, can never be considered reasonable in the eyes of the law.
So even if alcohol clouds your judgment, you're still responsible for your actions.
Absolutely. The law doesn't let us off the hook that easily.
Now, the SOA 2003 also outlines some pretty specific scenarios related to consent.
Yes, it lays out these situations where consent is either presumed to be absent, we call these evidential presumptions, or situations where consent is completely impossible, and those are conclusive presumptions.
Okay, so in these situations, even if someone doesn't explicitly say no, the law recognizes that true consent can't exist.
Exactly.
So what kinds of scenarios are we talking about here?
Well, Section 75 outlines the evidential presumptions, which cover things like violence or threats of violence, unlawful detention, the victim being asleep or unconscious.
Okay, so situations where it's pretty clear someone is not in a position to freely give consent.
Right, and even being given a stupefying substance falls under this.
Wow, it's really comprehensive.
It is, but remember, these presumptions can be rebutted, although the prosecution still needs to prove lack of consent, even if that happens.
So it's not a free pass for the defendant just because a presumption exists. The case of R.V. Ciccarelli really demonstrates this.
Oh, yes, that's a good one. The defendant tried to argue that he believed the victim consented despite a Section 75 presumption being in play.
But the court said, hold on, you don't just need to prove the presumption was wrong. Your belief also have to be reasonable.
It's a two-part test, and it aims to protect victims while ensuring fairness for the accused.
I like that.
A balance is really key.
All right, so what about conclusive presumptions?
Now, those are situations where the law says, nope, consent just can't happen here no matter what.
Okay, so no wiggle room at all.
None whatsoever. And Section 76 of the Act outlines two of these conclusive presumptions.
Lay it on me. What are they?
Well, the first one is when a defendant deceives the victim about the nature or purpose of the act.
Okay, so like the classic case of RV flattery, where the man tricked the woman into sex by pretending he was doing a medical procedure.
Yes, that's clear-cut deception about the nature of the act right there.
Absolutely. But then the lecture brings up R.V. Cheda and R.V. Devenold, and this is where it gets a bit more complicated.
Oh, yeah, those cases really highlight the nuances of deception.
So in Cheda, a man manipulates a woman into sex through fake text messages. The court decided this wasn't deception about the nature of the act itself, so Section 76 didn't apply. But then you have R.V. Devenold, where a man tricked a teenager into doing something sexual on a webcam by pretending to be a young woman. And here, Section 76 DID apply.
Because the deception went to the purpose of the act, the reason why the victim was engaging in it.
So the type of deception really matters when it comes to conclusive presumptions.
It does, and that brings us to another point that the lecture explores, the non-disclosure of STDs.
Okay, yeah, this is a tough one, isn't it?
It is.
So cases like RVB and RVDCA clarified that not disclosing an STD doesn't automatically trigger Section 76 or invalidate consent.
Right, it's complex.
It really raises a lot of questions about informed choice. Can you truly consent if you don't have all the facts? How much information is enough for consent to be valid?
And the lecture kind of leaves us pondering this. Does this approach actually protect a person's right to make informed decisions about their body?
It's a great question. I mean, ethically, there are a lot of gray areas here.
Absolutely. It's a prime example of how legal definitions, while essential, sometimes struggle to keep up with changing social norms and our understanding of consent.
So true. One last thing before we move on. I want to talk about what the lecture calls the complainant's mistake.
Okay.
They use R.V. Tabassum as an example,
Mm-hmm.
the case where a man pretends to be a doctor to conduct breast examinations.
Right, a case that really emphasizes the distinction between the nature and quality of an act.
Exactly. It established that consenting to the nature of an act doesn't necessarily mean you're consenting to its true purpose or quality.
Like in Tabassum, the women consented to medical exams because they believed the man was a qualified doctor. They did not consent to sexual acts masquerading as medical procedures.
It all comes back to informed choice, doesn't it?
It does. Consent must be based on a genuine understanding of what's happening.
Context is everything.
It really is.
Well, I think we've successfully unpacked the complexities of rape under the SOA 2003.
We've covered a lot of ground there.
We have. Now, are you ready to move on to some other offenses outlined in the lecture?
Let's do it. Each one has its own nuances and challenges when it comes to understanding consent and the boundaries of the law.
Definitely. Get ready, listeners, because we're diving even deeper in part 2 of our UK sexual offenses deep dive.
All right, let's delve into assault by penetration. This one's defined in Section 2 of the SOA, and it broadens the scope beyond just rape.
Okay, so how does it differ?
Well, it states that penetration can happen with any body part or object.
Any body part or object.
Yep, except for the mouth. That's important to note. And of course, it doesn't have to involve a penis.
So this covers a much wider range of scenarios then.
It does, but there's a key element here that the lecture emphasizes. The act still has to be considered sexual.
Right, because just penetration on its own doesn't necessarily equal a sexual offense. But how do you define something as broad as sexual in legal terms?
Well, luckily, the act provides a framework for that, too.
It does.
It does. Section 78 sets out a two-part test.
Okay, tell me more.
First, you ask, would a reasonable person consider this act sexual in its nature? If the answer is yes, you're done. But if it's not so clear-cut, you move to the second part of the test.
Which is?
Considering the context and the purpose behind the act, was it done with a sexual motivation?
So even an act that might not be inherently sexual could become an offense depending on the circumstances.
Precisely.
The lecture brings up RVH to illustrate this point.
Oh, that's a really interesting case.
A man pulls at a woman's tracksuit bottoms while asking for sex. The initial court kind of focused on his words, but the appeals court stepped in and said, no, you have to look at the act itself first.
It's about looking at the act in isolation, and then, if necessary, considering the surrounding context to determine if it was sexual in nature.
Makes sense. The lecture also mentions R.V. George, the case about the foot fetishist.
Ah, yes. That one really demonstrates how the legal definition of sexual can be both narrow and broad.
It does.
And it shows how the courts are trying to navigate this complex area of law, protecting victims, but also recognizing that what's considered sexual can change over time.
It's definitely a challenge keeping those definitions relevant and ensuring they're actually achieving what they're meant to achieve.
It is.
Okay, let's shift gears a bit and talk about sexual assault, which is defined in Section 3 of the SOA 2003. What's the focus here?
The key element here is touching.
Okay, simple enough. What else should we know about this offense?
The lecture points out that the touching doesn't have to be skin on skin.
Really?
Yeah, touching someone's clothing can be considered sexual assault too.
So even through layers of clothing, it can still be considered a violation.
Absolutely.
Wow, that really broadens the definition. Anything else about sexual assault that stands out?
There's one aspect that a lot of people find surprising, actually.
What's that?
The victim doesn't need to be aware of the touching for it to constitute an offense.
Seriously?
Yeah.
So someone could be touching me inappropriately, and I could be totally oblivious, and that would still be illegal.
That's right.
The case of R.V. Benekla established that the victim's awareness isn't a necessary component of sexual assault.
It's a really interesting point.
It is. It really gets to the heart of what defines violation, doesn't it? Even if you're not consciously aware of it happening, the violation's still there.
Right. It sort of speaks to a deeper level of harm, the potential for trauma, even in the absence of conscious recollection.
Okay, let's move on to Section 4, which defines the offense of causing a person to engage in sexual activity without consent.
Okay.
This one seems to cover a different type of scenario,
It does.
like where the perpetrator isn't directly involved in the act.
You're right. This section is about situations where someone might manipulate or coerce another person into engaging in sexual activity, even if they're not physically participating themselves.
So not the direct perpetrator, but the one behind it, pulling the strings, so to speak. The lecture gives this really stark example. A husband forces his wife to have sex with another man.
Right.
So in that scenario, the husband wouldn't be the one physically having sex with his wife, but he would be the one orchestrating the whole thing.
Exactly.
And what kind of charges would they be looking at in a case like that?
Well, the husband, even though he's not physically participating, could be charged under Section 4.
And the other man.
He could be facing rape charges.
It shows how the law recognizes that coercion and manipulation can be just as violating as physical force.
Absolutely. It's not just about what you do, it's about how you influence or control others, and that's taken very seriously in this context.
Now, we should also touch on Sections 5 through 15 of the SOA, which deals specifically with sexual offenses against children.
Ah, yes. This is a very important area of the Act, obviously, as children are particularly vulnerable to this kind of abuse.
The lecture mentions that these offenses are broadly split into two categories.
They are.
Can you explain the difference?
Of course. The first category covers sexual activity with a child under the age of 13. In these cases, consent is completely irrelevant.
Okay, so if a child is under 13, it's automatically an offense.
Exactly. It doesn't matter if the child seemed willing or said yes. The law recognizes that children of that age are simply not capable of giving informed consent to sexual activity.
It's about protecting children who are just too young to understand what they're consenting to.
Precisely.
Okay, what about the second category?
The second category covers sexual activity with a child between the ages of 13 and 16.
So, teenagers.
Right. And in these cases, there's a limited possibility for a defense.
A defense, what do you mean?
Well, if the defendant can prove that they genuinely believed the child was 16 or older, they might have a defense.
So they have to prove they didn't know the child was underage.
Yes, but it's a very difficult defense to successfully argue.
I bet, especially when you consider the severity of the offenses we're talking about.
Exactly. The burden of proof is on the defendant to show that their belief was reasonable, and that's a very high bar to clear. The law recognizes the power imbalances between adults and minors and the potential for exploitation that exists.
So they're really trying to protect young people, even if there's a claim of mistaken age.
Yes, the law errs on the side of caution when it comes to protecting children and teenagers.
Well, this deep dive into the UK's Sexual Offences Act has been quite an eye-opener. We've covered a lot of ground, from rape to sexual assault, and now these offenses against children. It seems like the Act really attempts to cover a lot of bases.
It does. It tries to provide a comprehensive framework for dealing with these sensitive and challenging issues.
And as we've seen, it's not always easy to define these terms or determine what constitutes consent.
It isn't. It's an evolving area of law, as our understanding of consent and the impact of sexual violence continues to grow and change.
Well, I think it's time to move on to part 3 and wrap up our deep dive with some final thoughts for our listeners. So we've spent the last 2 parts really delving into the legal definitions, the different offenses, the complexities of consent. It can feel kind of heavy, you know.
It can.
But beyond the legal framework, what else can we do as a society to really address these issues and create a safer world for everyone?
Well, I think it's important to remember that the law is really just one piece of the puzzle. It's there to hold people accountable, to punish those who do wrong, but it's not enough on its own to actually prevent these offenses from happening in the first place.
Right, like it's not just about punishing bad behavior after the fact, it's about stopping it from happening altogether.
Exactly. We need to move beyond just knowing the law and work towards cultivating a culture of respect and understanding when it comes to consent and boundaries.
So how do we actually do that? How do we create that kind of culture?
Well, for starters, we need to actively challenge harmful attitudes and behaviors, even when they seem small or insignificant.
Like what kinds of things?
It could be a joke that makes light of sexual assault, or a comment that dismisses someone's experience. It could be interrupting a conversation where someone's being disrespectful, or making assumptions about someone's sexuality.
So it's about speaking up, calling out those behaviors, even when it feels awkward or uncomfortable.
Exactly. We need to create a climate where those kinds of attitudes are just not acceptable.
And that goes beyond just romantic relationships, right?
Absolutely. This applies to all aspects of our lives. Friendships, workplaces, families, everywhere.
We need to be having these conversations about consent and boundaries in all of those contexts.
Yeah, we do. We also need to create safe spaces where people feel comfortable speaking out about their experiences, where they can access support without fear of judgment.
Right, because if someone has been a victim of sexual violence, it's so important that they feel like they can talk about it and get help.
It is, and it's not just about supporting survivors, it's also about educating everyone on how to recognize and prevent these offenses from happening in the first place.
So it's a multi-pronged approach: education, awareness, support, and challenging those harmful attitudes.
Exactly. We need to tackle this from all angles.
You mentioned earlier that the law is just one piece of the puzzle. Are there any other systemic issues that contribute to sexual violence that we need to address?
Oh, absolutely. Gender inequality is a huge factor. When women are systematically disempowered and their voices aren't heard, it creates an environment where sexual violence is more likely to occur.
Right, it creates these power imbalances that make it easier for someone to take advantage of another person.
Exactly. And power imbalances can exist in all sorts of relationships, not just between men and women. We see it in workplaces, in families, in communities.
So recognizing those power dynamics and working to create more equitable relationships is crucial.
It is. And then there are all the harmful social norms and stereotypes that we need to challenge, these narratives that perpetuate violence and make it harder for people to speak out.
Like the idea that men are naturally aggressive or that women should be submissive.
Exactly. Those sorts of beliefs can really create a climate where boundaries get blurred and consent is not taken seriously.
It's like it normalizes disrespect.
It does.
It's about recognizing these deeply embedded beliefs and actively working to dismantle them, which isn't easy.
It's not. It's a long and complex process, but it's absolutely necessary if we want to create a society where sexual violence is not tolerated.
I think this deep dive has really highlighted just how much work there is to be done. For our listeners who might be feeling overwhelmed by all this information, where can they go to learn more and find support?
Well, there are some amazing organizations out there doing incredible work on these issues. In the UK, I'd recommend Rape Crisis. England and Wales, they have tons of resources and support services for survivors.
Okay, Rape Crisis. What about other organizations?
The Survivors Trust is another great one. They have a helpline and offer counseling and support for anyone affected by sexual violence. And for those who identify as LGBTQ plus Trellin, there's Gallup.
Gallup. Okay, I'll make sure to include links to all of those in the show notes.
Perfect. And I just want to add that while we've been focusing on UK law today, these are universal issues. Sexual violence happens everywhere, and the principles of consent, respect, and bodily autonomy apply to everyone, no matter where you are in the world.
That's a really important point.
Yeah.
These are global conversations that we need to be having everywhere.
We do. So if this deep dive has sparked your interest, I encourage you to keep learning, keep challenging your own assumptions, and get involved in the movement to end sexual violence.
It's about creating a world where everyone feels safe and respected.
It is.
Well, a huge thank you to you, our expert, for guiding us through this complex and challenging topic. You've really shed light on some important issues.
It's been my pleasure. These conversations are so important, and I'm always happy to contribute in any way I can.
And to our listeners, thank you for joining us on this deep dive into UK sexual offenses law. We hope you've gained a deeper understanding of these offenses, the importance of consent, and the work that still needs to be done to create a safer, more just world for all. Until next time, keep learning, keep questioning, and keep advocating for a world where everyone feels safe and respected.